Lords, I rise with some trepidation to raise some problems with these amendments, if I may. I have to say that Baroness Smith of Llanfaes made an absolutely brilliant, compelling case for her amendments and has been amply backed up by others. But I still think if you look at what these amendments are doing, there's a danger here. I think that we've already discussed in recent groups the mission creep in relation to the concept of harassment, and we've talked about it a great deal. But I therefore am concerned that the Section 2A of Amendment 100 on the prevention of gender-based violence and harassment includes the prevention of emotional and psychological abuse. And I think that to bring that into the law is a very wide and broad set of rules in a workplace. And I absolutely am sympathetic to, of course, taking on some of the problems that we've seen in workplaces of people being stalked at their workplace, for example, or being stalked by fellow workers, or the kind of domestic abuse that's been described, the Harry's example, the rape and so on. All of these things are terrible, but we shouldn't shy away from the fact that it's quite difficult to legislate on every aspect of every intervention between employees in a workplace if we're going to broaden it out to emotional and psychological issues. That's one problem. It's overly subjective, and I also think that the use of gender-based violence is in danger of confusing us as well, because we now know that there is a confusion between gender rather than biological sex. We shouldn't shy away from the fact that that language has been confusing for some time. We need some clarity, not some muddying. It could turn workplaces, if we call it gender, into sites of perpetual ideological grievances and finger-pointing. To give you an example, Amendment 99(3)(c), it says that the aim is for a gender-responsive approach, which it says means taking into account the various needs, interests and experiences of people of different gender identities, including women and girls. Can I just point out that women and girls are not a subsection of gender identities? Gender identities are, have them if you want them, in my view. Women and girls, if we're serious about tackling violence against women and girls, do not throw them into this mix and have this, and certainly we can't have gender identities as a legal category by a well-intentioned amendment that in fact would undo the clarity which we've recently had. So I think it would completely, these amendments would completely conflict with the Supreme Court's clarification of the distinction between biological sex as a fact, as law, rather than gender identity, which I'm afraid is very often not just what people choose, but part of an ideological activism that I would argue has been incredibly damaging to sex-based rights for women and often in the workplace. We also need to be very careful about because I think it's 99(3)(b) talks of the duty of every employer to provide training to all employees in recognising and preventing violence and harassment in the workplace with a focus on a gender-responsive approach. Now, I mean, I get worried when the bosses are asked to provide training that's not about training to how you do your job, because training has become the vehicle through and the mechanism that's been used not to protect employees from harassment, but as a vehicle often for viewpoint conformity and an insidious form of harassment of anyone who doesn't conform. We have to really consider what this training consists of. So I don't want to just say, oh yes, training, that's a good idea then. I think that the danger of training is that it can introduce all sorts of problems. And in fact, training is the way that in most workplaces we now know people misunderstood equality law, because it was via training informed by third-party organisations involved in the gender issue that they started to, in fact, adopt what has been called by some cases in this as Stonewall law. And that's why so many organisations are now saying, well, we were doing what we thought was legal. But anyway, just to finish, Just to show you how complicated it is, I hope the noble lords read that incredibly moving and harrowing interview that was done with Karen Danson, one of the 8 Darlington nurses who's taking legal action against her employer, their employer, County Durham and Darlington NHS Foundation Trust, after they were forced to share a changing room with a male nurse who identifies as a woman and calls himself Rose. But as Karen explained in this interview, she came out and admitted that she had been abused as a child. She goes to work. As a nurse, she has to get changed, and in walks Rose, wearing only boxer shorts, full of holes as it happens, the details do matter in this instance, who kept and persistently asked Karen why she wasn't getting changed. And Karen, understandably, felt very disturbed. And she and her colleagues went to their bosses and the HR and said, this is our changing room, and these amendments are about sexual harassment in the workplace. This is our changing room. We don't want to get changed in front of this man, however he identifies, and what will you do about it? And what did HR say? They said that they were the problem, called them transphobic, said that they needed to be re-educated in trans inclusion. In other words, they were about to be sent on a training course. So I make my point that actually, if you're the wrong kind of victim in a workplace, in an ideological sense, you can actually be the victim of the training which tries to get you to accept right thing rather than actually protect your rights. So I really admire the spirit of the way the amendments were moved. However, I think they're absolutely wrong-headed and we should reject them.